Welcome to this tutorial on the examination of demand under URDG 758. If you are involved in trade finance, banking, or guarantee operations, understanding how to properly examine a demand under a demand guarantee is critical. Today, we will break down the importance of demand examination, key principles under URDG 758, and the steps you must follow to ensure compliance. So, let's get started. Why is it demand examination important? The examination of the demand is just as important as its presentation. Why? Because it determines whether the beneficiary will get paid under the guarantee. As a guarantor, you have a strict time limit to decide whether to accept the demand and make payment or whether to reject due to non-compliance. A wrong decision can have serious consequences like accepting an invalid demand may expose the guarantor to claim from the applicant, and rejecting a valid demand can lead to legal claims from the beneficiary. So, how do you know a fair and correct decision? That's where URDG 758 Article 19 comes in. Now we are diving deep into Article 19 of URDG 758, which sets out the rules for how guarantors must examine a demand for payment. If you are involved in trade finance, misinterpreting these rules could lead to unjustified payment rejections or wrongful approvals, both of which carry a major risk. The first and most important rule under Article 19A is that the guarantor must determine whether the demand is complying based only on the documents presented. The guarantor cannot investigate facts outside the document, and the decision must be made purely on the face of the documents presented. For example, if a demand states that the applicant is in default, the guarantor must accept at this face value that are not allowed to verify whether the applicant is actually in default. The guarantee is a documentary instrument and only the documents matter. Now, let's move to Article 19b, which explains how data in a required document must be examined. The data in a document does not need to be identical to the data in the guarantee. However, it must not conflict with the guarantee, other required documents, and the document itself. This rule prevents unnecessary rejections while ensuring consistency across all documents. Now, what happens if the guarantee requires a document but does not specify whether it must be signed or who should issue it? According to Article 19C, if the document fulfills its intended function and does not conflict with other required documents, it is acceptable. If the document is signed, any signature will be accepted even if there is no indication of the signatory's name or position. This means the guarantor cannot reject a document just because it is signed by an unknown individual unless the guarantee specifically requires a named signatory. For example, if the guarantee requires a statement of non-payment but does not say who must sign it, then a signed or unsigned statement will be acceptable as long as it meets the functions required by the guarantee. What happens to extra documents? A common question is, what if the beneficiary presents extra documents that are not required? According to Article 19D, if a document is not required by the guarantee, it will be disregarded. That means the guarantor does not need to examine it and may return it to the presenter. For example, a guarantor requires a bill of lading and a commercial invoice, but the presenter also submits a packing list. Then, the packing list will be ignored because it is not required. Now, another common question is, should the guarantor recalculate amount? So, the recalculations are discussed in Article 19E. If the guarantee states that the amount payable varies based on a formula, for example, based on an exchange rate or an index, the guarantor does not need to recalculate it. The guarantor must only check whether the demand follows the formula stated in the guarantee. They do not need to verify the calculations themselves. For example, a guarantee allows a claim amount based on a percentage of the total project cost. Then, if the beneficiary submits a demand with a calculated amount, the guarantor does not need to redo the math. They only need to ensure the formula was followed. Lastly, Article 19F covers legalized, certified, or visa document. If a guarantee recorded document is to be legalized, vised, or certified, the guarantor must accept any mark, stamp, or label that appears to meet this requirement. For example, if a document is required to be certified by the Chamber of Commerce, the guarantor must accept any stamp or mark that appears authentic, even if the specific words certified by Chamber of Commerce are missing. This rule prevents unnecessary rejections due to minor formatting differences. Before we wrap up Article 19, let's review the most important points from it. A complaint presentation is determined based on the documents alone. That means no external verification required. Data must be consistent but does not need to be identical. If the document's details such as signature or issuer are not specified, it is accepted as long as it serves the functions. Remember, non-required documents are ignored and guarantors do not need to recalculate figures. They only check compliance with the stated formula. Finally, legalization, certification, and visa stamps are accepted based on the appearance. Following these rules ensures that demand guarantees are reviewed fairly and efficiently. Now we have discussed about URDG 758 Article 19, which provide key principles for examining a demand. When examining a demand, you only look at the document submitted. You do not ask for clarification, verify details externally, such as in internet search, and investigate the actual performance of the contract. The only exception is when the demand refers to non-documentary conditions under URDG 758 Article 7, such as checking an index or the guarantors on record. The examination is on its face. The term on its face means that the examiner must read and assess all submitted documents together to determine compliance. However, it does not mean checking if a signature is valid, confirming if the signatory had authority, unless the guarantee explicitly requires it. In short, the examiner must focus on whether the demand as presented meets the guarantee's condition. The demand must be a complaint presentation. Under URDG 758 Article 2, a complaint presentation must conform to the terms and conditions of the guarantee and URDG 758 rules and International Standard Demand Guarantee Practice. If a presentation meets all these criteria, it is complaint and the demand should be honored. In addition to URDG 758, the International Standard Demand Guarantee Practice or ISDGP provides additional guidelines on this. ISDGP J1382-157 expands an examination principles and help us to ensure consistency in demand handling. Before applying ISDGP, you must understand its relationship with URDG 758 and how it supports the determination of a complaint presentation. Using both URDG 758 and ISP 98, you can ensure a legally sound and fair decision on demand examination. Now we will break down the critical rules and principles that govern how guarantors determine whether the demand is compliant under URDG 758 and ISDGP J 138 to 159. Understanding these rules is essential because an incorrect rejection or acceptance of a demand can lead to legal disputes, financial losses, and a reputational damage for banks and financial institutions. So, let's dive in. The first thing to understand is what makes a demand complying. According to Article 2 of URDG 758, a complying presentation must meet three criteria. First one, it must comply with the express terms of the guarantee. Second, it must comply with the URDG 758 rules. Remember, if it is not excluded. Third, it must follow international standard demand guarantee practice. These three standards must be applied in order. That means a demand cannot be rejected based on ISDGP if it complies with the explicit terms of the guarantee. Similarly, a demand cannot be rejected just because it does not perfectly match URDG 758 if it meets the terms of the guarantee. Now, let's talk about what guarantors must do when examining a demand. Guarantors can only examine the documents provided. They cannot verify external facts or rely on external resources. Guarantors must ignore non documentary conditions. That means, if a guarantee refers to an underlying contract, the guarantor cannot assume additional requirements from that contract unless they are explicitly mentioned in the guarantee itself. For example, if a guarantee says the applicant is in breach of payment obligation under the contract from April 1st to August 20, then the guarantor cannot reject the demand just because it does not mention the contract date or contract reference number, unless the guarantee explicitly requires it. Now, what happens when extra information is provided? A common question is, what if the beneficiary provides extra documents or information that aren't required? Non-required documents do not need to be examined and they are simply ignored. However, if a required document includes conflicting, non-required information, the demand becomes non-compliant. Now, common errors and how they affect compliance. If a guarantee's amount varies based on an index, the guarantor is responsible for recalculating the correct amount before approving a demand. The beneficiary cannot claim more than the adjusted amount. Now, small typos usually don't make a demand non-compliant unless they change the meaning of the document. Example of an unacceptable typo is a contract number must be exact. So if required documents state contract number 123 instead of 231, the demand is non-compliant. Now, company names and abbreviations and punctuation marks. Some abbreviations are acceptable like INC for incorporated, LTD for limited. Similarly, missing punctuation mark usually does not matter unless they change a number's value like 14 versus 1 by 4. Now, who can issue a document and who must sign the required documents? Another important rule, if a guarantee requires a document to be issued by the specific person or entity, the document must appear to come from the entity. It can be verified by a letterhead, signatures, and official stamp. However, it is better to avoid naming a specific individual because they must no longer be available when the demand is made. Now, examination timeline. That means the 5-day rule. One of the most crucial rule in Article 20A is the 5 business day examination period. The guarantor has exactly 5 business days from the date after the presentation to review the documents and decide whether to approve the demand or reject it with a clear explanation. Remember, the number of documents or their complexity does not extend the 5-day deadline. And even if the bank is open for just half a day, it still counts as a full business day. To wrap up, let's review the most important points. A complaint presentation must meet the terms of the guarantee, URDG 758 and ISDGP. Guarantors cannot add extra complaints requirements beyond what's stated in the guarantee. Non-record documents are ignored, but conflicting data in record documents cause rejection. Minor typos and missing punctuations usually does not matter unless they cause confusions. Finally, the 5-day examination rule is fixed and no exceptions to it. Following these rules ensures that the demands are processed fairly, efficiently, and legally. So that is it for today's tutorial on examining demand guarantees under ISDGP and URDG 758. If you found this video useful, don't forget to like this video, subscribe for more trade finance insights, and leave your questions in the comments below. Thanks for watching and see you in the next video. Till then, take care. Bye bye.